Sovereign citizens, Appendix and Citation framework, sources, authorities, and symbolic references. 1. Foundational legal sources. 1. The Constitution of the United States, the supreme contract of delegated authority, serves as the foundational framework for lawful delegation, separation of powers, and the recognition of the individual as sovereign beneficiary of government service. 2. The Declaration of Independence establishes consent as the condition of governance and rebellion as lawful remedy when consent is breached. 3. The Federalist Papers provide interpretive insight into the intent of the founders concerning jurisdiction, consent, and limited government. 4. The Uniform Commercial Code, UCC, the administrative architecture of modern commerce, recognized in all 50 U.S. states as a unified system for defining rights, obligations, and negotiable instruments under contract. 5. The Common Law of England, the inherited framework upon which American jurisprudence rests, emphasizing the supremacy of equity, precedent, and the duty of conscience over mechanical rule. Footnote: Foundational sources define the jurisdictional pillars of modern American law, contract, consent, and commercial administration. 2. Secondary legal authorities. 1. Black's Law Dictionary, 11th ed., the definitive lexicon of legal interpretation, clarifies that person denotes an entity of law, not necessarily a living being. 2. Maxims of equity, including, equity will not suffer a wrong without a remedy, and he who seeks equity must do equity. Together they form the moral compass of judicial discretion. 3. Restatement, 2nd, of contracts, codifies the doctrines of offer, acceptance, consideration, and discharge, the skeletal framework of commercial obligation. 4. Story, Joseph. Commentaries on Equity Jurisprudence, 1836, bridges moral and legal reasoning, describing equity as the soul of the law. 5. Coke, Edward. Institutes of the Laws of England, 1628, early articulation of the rule of law as the restraint upon sovereign and subject alike. Footnote: Secondary authorities expand on the moral and procedural scaffolding that sustains legal interpretation. 3. Economic and philosophical sources. 1. Adam Smith, The Wealth of Nations, 1776, defines commerce as an organic extension of human cooperation, not competition. 2. Friedrich A. Hayek, The Constitution of Liberty, 1960, argues that order in society arises from spontaneous coordination, not command. 3. Ludwig von Mises, Human Action, 1949, identifies all economics as a reflection of human choice, linking moral and market law. 4. John Locke, Second Treatise of Government, 1689, asserts property as the fruit of labor and consent as the foundation of governance. 5. Cicero, De Legibus, on the Laws, establishes natural law as universal and eternal, preceding all civil statutes. Footnote: These texts supply philosophical context linking legal authority to moral and economic behavior. 4. Symbolic and historical references. 1. The Great Seal of the United States, interpreted as a symbolic trust indenture reflecting dual jurisdiction, public law and private equity. 2. Freemasonic numerology and heraldry, examines the recurrence of the number 13 as symbolic of completion and sovereignty. 3. The Eye of Providence, represents omniscience and accountability, reinterpreted as the individual's awakened awareness within the system. 4. Biblical references, King James Version, including render unto Caesar and the borrower is servant to the lender, illustrating legal metaphors embedded in theology. 5. Ancient Trust Structures of Rome, Fideikommissum, early precursor to modern trust and equity systems, reinforced the division between legal and beneficial ownership. Footnote: Symbolic and historical references reveal continuity between ancient jurisprudence, moral law, and modern legal metaphors. 5. Modern jurisprudential commentary. 1. Robert Bork, The Antitrust Paradox, 1978, demonstrates that regulatory zeal often harms the competition it intends to protect. 2. Harold Demsetz, Information and Efficiency, 1970, identifies the nirvana fallacy, cautioning against comparing real-world markets to impossible ideals. 3. Friedrich Hayek, The Meaning of Competition, 1946, debunks the myth of perfect competition, reinforcing the dynamism of entrepreneurship. 4. Milton Friedman, Capitalism and Freedom, 1962, defines voluntary exchange as the highest expression of human liberty. 5. Thomas Sowell, Knowledge and Decisions, 1980, argues that dispersed information is the true foundation of efficient law and economics. Footnote: Contemporary scholarship reaffirms the limits of regulation and the necessity of individual judgment within lawful order. 6. Maxims, aphorisms, and closing principles. 1. Ignorantia juris non excusat, ignorance of the law excuses no one. 2. Consensus facit legem, agreement makes the law. 3. Equity acts in personam, the conscience of the court reaches the person, not merely the act. 4. Ex dolo malo non oritur actio, no right of action arises from deceit. 5. Fiat justitia ruat caelum, let justice be done though the heavens fall. So what does that actually mean? It means even Latin had a sense of drama. Footnote: Legal maxims serve as the DNA of jurisprudence, compressing centuries of moral reasoning into a single authoritative phrase.